those of you who don't follow Missouri case law, there was a class action suit filed by a group of sellers in Missouri who sued the National Association of Realtors regarding what they viewed as price fixing and collusion under an antitrust law, and ended up winning. At the local level, it was appealed and the parties reached a settlement. But kind of coming out of that case, there was a lot of discussion about what types of agreements brokers are using, what types of disclosures have to happen, when, if ever, cost sharing can be kind of used in a residential setting, and then also what type of information you need to share with your clients if you have kind of a compensation agreement with another broker.
Hey guys, welcome to episode 66 of the Realized Gains podcast. I'm Stephen Tran. I'm an Oregon and Washington realtor, and I invest in multifamily and single-family homes.
And I'm your co-host, Jordan Lee, a mortgage lender based here in Portland, Oregon, licensed in 9 states, and I invest in single-family homes and a duplex as well.
Yeah. And so, Jordan, hey, who did we have on the episode today?
Oh, yeah, we had a great episode today. We interviewed a high school classmate of mine, Margaret Gander-Vo, who's with a local firm, Saalfeld, Griggs.
Yeah. No, it was great. I mean, it's really good to know when you should work with a broker like me or when you should be working with a real estate lawyer.
Yeah, we talked a little bit about that, about, the NAR settlement and, what it means to work with an attorney if, you're just choose to do that over a broker, or a circumstance where a broker might want to get an attorney involved if it's a very complex. We talked a little bit about easements.
Yeah, easements, like basically your plat lines.
Anything weird coming up in title.
Yep, it's that,
HOA document, weird stuff.
Exactly.
Right?
How do you deal with how you structure your partnerships, just a bunch of other things that maybe your agent wouldn't know. Not me, though. I would know everything, clearly.
No, we talked a little bit about creative financing, land contracts, and yeah, it's a super interesting episode just to get the legal side.
Yeah, no, and definitely good to have a real estate lawyer, in your back pocket in terms, in times when you get into a subject that you might not touch a lot. I know us realtors, we should know a lot of these things, but sometimes this is something we might not touch on a regular basis.
Yep.
They do so. So, it's
or
good
you
to
want
know.
someone that can handle the extra liability.
Yep. And so, we have a really great episode kind of touching on all of that. And if you wanted to know more about real estate law, check out this episode. Hey guys, welcome to the Realized Gains podcast. We're on episode 66. I'm Stephen Tran.
And I'm your co-host, Jordan Lee, and we're super excited to have a high school classmate of mine, actually, Margaret Gander-Vo with Saalfeld Griggs, right?
Yeah.
So, hey, before we get started, first of all, she's an attorney, so we want to just make the disclaimer that, we're not giving you legal advice. We're just having a friendly conversation here. But before we get too deep, Margaret, do you want to just, talk a little bit about your background, where you're from, and how you kind of found yourself in the legal and real estate field?
Sure. So I have been practicing in Salem for about 7 years now. I specialize in real estate and land use with kind of an emphasis on land use. I have practiced at Saalfeld Griggs my entire career, and our practice is kind of focused on providing excellent service to commercial clients within Salem and Oregon generally. So we do work with developers and real estate transactions across the state. We're a little bit, in my practice group, we're a little bit unique in that we have both a transactional and a oral advocacy focused practice. So we do kind of all stages of development, from acquisition with real estate transactions through entitlement procurement. So any zone change, conditional use permits, site plan reviews, kind of walking through in a more project management focus, or kind of working with a developer team, depending on preference of the client. And then we do kind of loan restructuring and refinancing.
Because typically on any like larger development, it's you have to have an attorney, right, interfacing between you and the lender as well as you and the other party, right?
I think that in most instances, attorneys provide real value, especially if they have experience in the particular jurisdiction that you are developing within, just because they're able to kind of move across disciplines in a way that I think is a little bit unique. You don't always have a project manager who's able to move through all of the different stages of development, and so we can step in and be as involved as a developer and developer team would like. But there are also projects where we are the primary interface between the jurisdiction and the developer, the lender and the developer, the kind of background property owners if the project is still under contract for sale, because in many instances we're called in to do entitlement work while the sale is still pending. So I think it adds value.
Can I ask, when you're getting your law license, did you know you're going to be in the real estate space, or was that something that interested you?
When you're growing up, where you're like, I'm going to be a real estate attorney.
You know, it's funny. I was always really interested in history, and so there aren't a ton of jobs for people who study history, and law is kind of a natural fit. But in particular, land use law and real estate law do lend themselves really well to history type kind of research and review. So when I was a kid, I did think that I would end up being an attorney, and my dad had worked for a surveyor for a while, and he was like, well, land use attorney.
Oh, okay. So the seed was planted pretty early. Okay, interesting.
So I was born a land use attorney. No.
But it wasn't your first. It wasn't your first career, though, right?
No, I went into the Peace Corps. I graduated in 2008, went into the Peace Corps, and when I came back, the market was bad. So I I worked at a real estate developer kind of subdivision.
Oh, so you saw the other side too.
Yeah.
Okay.
Type work in Salem for a while before I went back to law school, but it was like a year. It wasn't much.
So did that company like kind of pull you back in once you finished your license? Did they have a use for you specifically?
No, they had kind of moved through the actual planning portion. They are actually a client of the firm, but we don't do much work for them anymore. And they sold to a national developer, so they're kind of done too.
Huh, interesting. Does that happen? Do you see that happen a lot, like mergers and acquisitions for developers once they get to be a certain size? Is that a path for a lot of developers, like just eventually sell to a bigger company?
Yeah, it's not typical right now, but kind of across all areas in all industries right now, we're seeing so much consolidation that my guess is eventually, yes, it'll start to kind of consolidate into larger kind of either national or multinational companies with kind of local expertise.
So part of the reason why we wanted to bring you on is because I think, the industry, there's big change coming on, especially, in our state where it wasn't standard to do. I mean, that's not true. I mean, lots of agents did do buyer's agency agreements. But, I mean, I feel like we'll have clients or folks that are interested in potentially looking at the option of working with an attorney to review documents instead of working with a buyer's agent. And so we're kind of interested in what you've seen previously. I mean, obviously it's a little bit early to have seen a lot since the law took place, but we're interested in how that kind of process works for you currently.
Sure. Do you want me to give a little bit of background around the case?
Yeah.
Okay. So, for those of you who don't follow Missouri case law, there was a class action suit filed by a group of sellers in Missouri who sued the National National Association of Realtors regarding what they viewed as price fixing and collusion under an antitrust law, and ended up winning at the local level. It was appealed, and the parties reached a settlement. But kind of coming out of that case, there was a lot of discussion about what types of agreements brokers are using, what types of disclosures have to happen, when, if ever, cost sharing can be kind of used in a residential setting, and then also what type of information you need to share with your clients if you have kind of a compensation agreement with another broker. And so that, because there wasn't really resolution, there was a settlement, right. And the settlement is kind of under court review, but we don't know if it'll become public, and likely it won't. A lot of other state regulators kind of stepped in and passed legislation to help provide some certainty on both sides. So in the most recent short session, the legislature passed kind of a list of requirements formalizing the types of agreements that happen both on the seller side and on the buyer side, and then putting some prohibitions in around future listing agreements. So kind of what we would maybe call in another setting a non-compete clause, where you are obligated to continue to use the same agent for other transactions, as well as requiring disclosure of any shared compensation agreements, which wasn't the norm in the past. I think if you have done a series of transactions, you usually understand that buyer and seller are going to split the commission. Seller is going to pay it out of the purchase price. Buyer is not going to pay anything, but it does kind of make the transaction go a little bit smoother when both sides are represented. So coming out of that, what we're anticipating is not a huge shift in the way that those agreements are formalized, because there are existing written agreements for both sides that many firms use. But there are going to be more specific disclosures, and there is a little uncertainty about when those agency agreements will end and what the penalties are for kind of a new agent stepping in if there are concerns about an existing agency relationship. And
so like if that you're saying that if a buyer is signed with a consumer, a buyer is signed with one agent, and they, for whatever reason, choose to go with a different agent, you're talking about the liability for the new agent?
I would say the liability for the new agent and the ability for a clear termination for the buyer.
Oh,
and
okay.
I think it depends a little bit on the sophistication of the buyer and whether or not they're kind of well informed of what their rights are and what their ability is to move on.
Almost like making a more clear and disclosed relationship of how this agency works.
Right. And I think there was space for setting kind of a more standard written agreement on both sides. Whenever the legislature fixes something, there's always room for improvement. So
of course, yeah.
I think we'll see that come out in rulemaking from probably the Oregon Real Estate Association, and I'm sure there will be good and bad there too.
Yeah, I mean, I'm part of the PMAR board, and I know they're working on those documents now, and they should be out in probably the next month or two. But I mean, I hear that this settlement is not going to be really finalized until sometime this summer.
Yeah, and because it's a settlement, and because it was in Missouri, it won't really have any presidential value here. It's more norm setting for the industry. And when you have realtor associations or listing agent coalitions that span the nation, there is some just rippling impact.
Yeah, and I'll say that there's a lot of misinformation out there right now. What are some of the big ones that you've heard? Like, you don't have to pay your buyer's agent anymore. They're working for free. How's this working now?
I actually haven't heard any, because we are usually involved in residential transactions when there isn't a broker on one
Right.
side. And we're kind of stepping in to those shoes and kind of fulfilling that role for folks. So it's not really something that we've heard a ton about. We'll probably start hearing things when like the agreements start to fall apart. And
well, I'll say this, it's funny, like, okay, I don't want to go with the broker because I don't want to pay my broker, but then I have to pay my lawyer. And are you going to be going through the inspections and telling them, like what they should get fixed and what's, what shouldn't?
We can do that. It is part of our license. And we do sometimes just kind of say, well, I would ask about these things. And it is interesting because like negotiating isn't necessarily part of what we usually do in those scenarios, which has been kind of based on the market fine, because what buyer is like, no, I am going to need to get this thing fixed that I'm paying, $200 above asking for because there are 6 buyers behind me.
Oh, yeah.
Right.
But, it is something that we are licensed to provide advice on. So I guess we could, in that scenario, provide advice.
Okay. And, I mean, I'll say this. What's more cost effective, and what type of consumer should go with a lawyer over an agent?
Well, what was your last commission?
2.5%.
So 2.5% on.
I don't know. It's just I'm just gonna make up a number like $500,000 household.
So if we look at doing, my billable rate is $320. So if I am just doing a review of kind of the transaction and kind of working out kinks and providing responses on any financing questions, I mean, we usually come in around $2,000, sometimes $3,500. So
that'd be like the base review, and then maybe like a few hours of like back and forth questions on a relatively straightforward transaction where someone's getting like a conventional loan, and they're there's not too much repair addendum stuff.
Yeah.
Well, she could handle it, obviously. So.
Do you sometimes find transactions that get really complicated that you end up having to bill more than you initially thought?
Yeah, I think there's always room for just kind of transactions getting a little bit more complex than was initially anticipated, or the scope of work changing. So saying that you want to have a contract reviewed and then actually wanting someone to kind of hold your hand through the full transaction, those are different scopes. And so they have different costs associated with them. Where I most regularly am involved in a transaction, especially if it's a simple residential transaction, is because there is some complicating component that an attorney is better suited for than a broker, because it needs some type of written agreement that's hyper customized or
higher level of liability maybe that a real estate agent doesn't necessarily feel comfortable taking on.
Yeah, and I have a lot of brokers that I work with who will call me and say, hey, this easement doesn't look quite right. Can you look at this? And so when an attorney is involved in a transaction, there is a higher level of kind of required due diligence. So if I get a title report, I'm going to not just look at the exception list. I have to read all of the actual exception documents and provide legal advice on whether or not that's a transaction that is properly being identified with accurate exceptions. And so providing that level of service is usually one that real estate agents aren't comfortable with, because it's one they're not licensed to do.
I mean, title stuff can be really complex
and dense.
And like just unexpected stuff that you just don't have. Nobody really has the experience to do with it because it's completely unique to a situation. Or like, for example, you'll get questions. I feel like that is the really hard one for me is always condo. Like, you go through this 350 HOA thing for me? And I'm like, well,
I don't know if I can read that much without falling asleep.
Well, and it's not only that, it's like, do I actually understand what all the implications are? Like, I know from colleagues and friends, like, I know people that have had trouble with financing because of XYZ reasons. I know that you can get, fees that can come in that, I know a lot of these things, but I wouldn't be able to give any sort of legal advice on like what that could mean for you for the long term. And so I think that's another typical situation where you're like, hey, you might want to have an attorney go over these condo documents if you're at all worried about any of these things on here.
Mm-hmm.
Sometimes there's confusion about like plot lines. And like, that's, luckily I haven't been in that situation where somebody's like, that doesn't look right. Like, how much land do I actually have? And then I'm sure there's disputes with the neighbors. Like I said, luckily I haven't been there yet, but obviously I think that I would go to a real estate lawyer with that. And how would you deal with that type of situation? How does like a case like that work?
So usually in that type of situation, the question becomes, is this something that the buyer or seller want to deal with before closing, or is this going to be something that we need to do an addendum for and identify this as a post-closing item and kind of work through to resolve it? And usually, I mean, if it's an illegal lot issue where the lot hasn't been properly formed, the seller can't close that transaction because they're selling an illegal unit. And so that becomes a conversation of how are we going to fix that? Is it possible to get it validated quickly, or are we going to have to go through a full historical review and do like an actual complex legal lot verification? And then it just kind of depends on timing. In that type of situation, we would advise on the timing, we would do the work, and then usually we are able to either get that project closed and the transaction is finalized and everything goes fine, or the buyer usually backs out, and then we end up usually fixing it for the seller anyways because they can't sell it until it's fixed.
I'm assuming like, just because it's an agent who just like, okay, I'm going to use the old listing, put this thing out here, not doing their due diligence. They're not going out with a surveyor looking for those coins and trying to figure out, what is the exact square footage. So I'm assuming there's probably a couple of those transactions that get through anyways.
Oh yeah, absolutely. Especially in situations where lots have been divided, but they were divided in like the 80s when there were land use laws, but nobody was following the land use laws.
Right.
So those types of situations all the time with farmers who had just deed the southern 50 acres to whoever, and you're like, you don't have that. So it is a lot of just kind of, in the transaction space, we do kind of play both roles where we're resolving specific issues and then also managing the transaction in a similar fashion to a broker.
Yeah. And let's go back to easements because let's just say I've had to explain easements a couple of times to my clients, and I have to kind of like read up on it again to refresh myself. I'm sure you deal with that all the time. How can we explain to our buyers and consumers what an easement really is and what issues can arise with an easement?
So the main thing with an easement is, so the definition of an easement is equity interest in the property of another. So it means you are entitled to use someone else's property for a specific set of uses. There are other ways that you could do that. There are licenses, but the most common form is an easement. If you are buying a property that's subject to an easement, there are a few questions. One is there an easement agreement that's associated with it? Mm-hmm. So if you are buying a property that has a roadway easement.
My property has that.
Yeah, a lot of properties do. Are there terms associated with that easement that is encapsulated in a written agreement? Or are you buying an easement that doesn't have an agreement and so is then subject to the statutory defaults? Mm. So one, you want to understand what your rights are under that easement because you want to be really sure that you have legal access. So if you are only taking access to a public street off of an easement, you need to be sure that that easement is in place. And there was some recent case law that determined, which is bad law, but it is law. It determined that if an easement isn't properly conveyed to a third party via a deed, that easement doesn't actually exist. So if you're looking back at the deed for your property and that easement is never listed in the deed, or there wasn't an easement agreement conveying from the grantor to a third party, then that easement technically doesn't exist. There are equitable rights and you can get it kind of reestablished, but you have to go through the process of reestablishing it.
So, like, for example, I have a driveway that my neighbor, the only way to access their garage is through this driveway. And she's told me that, and I remember during the transaction there was an easement there. I don't remember seeing a deed or any specific paperwork for it, but she's always like, oh yeah, I have like the right to use this.
Sure.
So it would be worth making sure that there's some sort of terms for that.
Yeah, and if it's something that is really minimal incidental usage.
It's not like I'm trying to block things.
Yeah.
It's like,
Yeah, it's one thing if normally everything is fine and people don't really care, and it's like a driveway that's already developed, and so it doesn't hurt you to let her use it. Hypothetically, you then have some interpersonal problem that spikes.
Right.
And then you're just like, well, you can't use this corner of my driveway.
Right.
And things devolve from there, and that's usually the problem with easements. So the mechanisms for not getting into this kind of petty feud over the corner of a driveway is to just make sure that easement was validly created and has an agreement associated with it.
And what about, like, liability? Like, if there's some accident that happened there?
Yeah. So usually in your easement agreement, liability would be allocated to whoever it's supposed to be allocated to. Typically in our agreements, we will say that any person who is coming onto the property as a result of an invitation or kind of permission structure from either of the parties would be liable. Okay.
So it's not like because it's your property, it's automatically, if someone else is using it, it's, okay, yeah, that makes sense.
Yeah, and if there isn't, I haven't looked at the statutory defaults in a while, but it probably is similar. If you have someone who you've invited onto the property and it's technically not yours, but you have an easement right.
Right.
Typically, you're responsible.
You're responsible, yeah.
Those folks.
Which makes sense.
Yeah.
Yeah, and so, I mean, can you talk about like your split between regular home buyers, standard residential versus like commercial?
Yeah. So usually when we're doing residential transactions, they tend to be family members or kind of clients that come in through some other type of work that we're already doing for the firm, and we do a review of the sale agreement and we say, yeah, this looks fine, or, well, let's tweak these things. Often when I'm involved in a more typical residential transaction, it's because I'm drafting the financing documents that go along with it, because it's either a seller carried finance situation or it's like a family member is providing a loan or some type of like
some sort of transfer from one family member to another that's not using conventional financing or normal, just simple purchase contract.
Yeah, and we also have an estate planning department, so often we'll do kind of distributions out of the trust, either through a sale agreement to a beneficiary where there are multiple siblings and one person is buying mom and dad's house. We'll draft the sale agreement and then do the transaction associated with that. So of my transactional practice, I would say residential probably takes up a third, typically around a third.
Okay.
Yeah.
I meant to ask about residential earlier. We were talking a little bit about fees, how it's structured is a little bit different from, it's more hourly based than like a percentage of the price base. Are you able to also have those fees paid for in the same way that realtors are? Like, are you able to have the seller's agent pay for the attorney's fees in the same way?
The seller agent or the seller?
Either or, yeah.
Usually, yes. So the way that we normally handle a situation where a third party is paying our fees is we still bill the client gets reimbursed, or we can bill into closing.
Yeah, like the paid through closing basically is what I mean. Yeah,
and then we just show up as a line item.
Right.
But our engagement is always with the person who hires us. So if a seller's broker is contacting us on behalf of a buyer who's unrepresented, we might communicate with the seller agent or the seller, but buyer is our client, so all of our kind of confidentiality, our fiduciary requirements all stay with client, and explaining that can be complicated.
So I'm assuming you have a lot of sellers agents schmoozing you, trying to get some information.
No, usually agents know that we can't tell them things.
Yeah.
But they do tend to be the ones who are like, what's happening with this? Where is this going? And you're just like,
can't tell you.
I don't. And that can also drive up prices. So when an attorney is involved and both brokers are kind of sending requests for information or kind of status requests, that
you have to bill the hourly work for that.
Yeah, and I know before this podcast we had a quick chat about fiduciary responsibility, and technically I believe in my license, we're supposed to be fiduciaries for our clients, but obviously, we're incentivized by this big payout. Can you kind of talk a little bit about that?
About
just the difference in liability or the fiduciary liability between an attorney and a real estate agent.
And I will mention that I'm sure I know a lot of agents who are not true fiduciaries.
Yeah, so I think what we see as being the primary difference between broker liability and agent liability is there is kind of a cap on liability that is associated with an agency license that isn't associated with an attorney license. So we have a specific set of duties: responsiveness, confidentiality, fiduciary duty, and then and making sure that our client is well informed and kind of well protected. So an attorney liability doesn't just necessarily relate to one element of the transaction or making sure that you're negotiating in good faith and kind of advocating. It's zealous advocacy in all areas of your scope of representation, which can carry quite a bit of liability, especially associated with residential transactions where you have unsophisticated buyers. It's not just your responsibility to provide them with the information, it's your responsibility to make sure that they're well informed about the decisions that they're making, which I think for good brokers and good agents, they feel the same, but it's required for us.
Yeah, I mean, we were talking about the kind of the pay structure, but I'll say this, I've had a lawyer in the past where I felt like they were kind of milking my time in a sense. Obviously, that doesn't really feel like they're being a fiduciary for my needs.
Yeah, and I mean, there are bad brokers, there are bad attorneys. Yeah. So it is kind of across the board. I think what can feel like that from a client perspective is often just making sure that you kind of have covered all of the bases, that they don't just say that they understand what you're telling them, that they do actually have a certain level of understanding, that you feel like they are accurately appreciating the risks that are associated with their transaction, or kind of why you think the mitigation is important. And I think the other side of that is brokers don't really have the ability to fix all of the problems, right? Attorneys, in theory, can fix a lot of the problems.
Yeah.
But being able to either through experience or kind of risk analysis say, you know what, you really need to get this easement fixed, and saying, you know, this is a really small area of the property. It's a right, but it's not a substantial right. Let's talk about what this really means for you practically and what the value is. That's just something that comes with time and experience.
Yeah, that kind of judgment of what problem could cause huge problems and what could cause small problems, I guess.
Yeah.
Yeah, with like, as you mentioned, neighbor disputes, or just being petty. Is like, oh, you know, your plant is over 2 feet into my plot, and like, which I've you know, once the neighbors get petty, you know, I've seen an apple tree kind of hanging over a fence, and people getting crabby because they just didn't have a good relationship. So.
Yeah, and I think it's especially when you are looking at an asset class that in a lot of instances has a ton of deferred maintenance, and you have an ownership class that is aging in place a lot longer than historically has been the case. I think from my perspective in transactions, making sure that people understand that, yeah, that relationship might be fine now, but when you go in and you're tearing that house apart, just understanding how that risk can change from, yeah, today it's fine, to you've kind of come into somebody's neighborhood and are tearing apart something that they don't have an ownership interest in but have definite feelings about is part of that risk analysis.
Yeah, I feel like growing up there, you know, in the Cully neighborhood in Portland, like I feel like somebody took out like a historic tree or something, and obviously it's on their land, and the whole neighborhood just went to bits. There was a whole news thing about
Got
it.
their torches out.
Yeah,
torches
I'm
and
just like,
pitchforks.
for me, I'm just like, it's a tree. I don't really understand, but you know, like what can they do other than being upset? Is there anything the neighbors can do? It's not their land, right?
For the most part, no, there isn't. So when things
they could tell the
changing,
city, and the city could find them, right?
Yeah. Yes, if they are actually doing something that violates a city code or an ordinance or regulation, they can report you, and obviously that's going to have an impact. I think the bigger question is, it's not those situations. It is more the easement situation where you're like, yeah, this looks fine when you're anticipating everything going exactly the way that it should. But what happens when it doesn't? And are you adequately protected if this just kind of, if for some reason it's not specific in your easement that someone can't put a fence over the top of it, and then there's a gate that you don't have a lock to because it's technically not your property, that you can't get to your house. Right. So it's more just understanding the worst case scenario and making sure that the worst case scenario is either mitigated or
talk
not
about
that
petty.
bad.
I got a scenario, totally hypothetical. Bamboo, all right. As you know, it can travel.
Sure.
Let's say you purchased a home. There was bamboo already planted there, and it has spread into the neighbor's yard. Would that be something, and you might not know the answer to this, but is this something that would be your responsibility as the owner of that of the property and the bamboo?
No. Hypothetically. So
it's just interesting because it's like under, it's not over,
so, and some of those things go back to like English common law, and for plants that spread into someone else's property, you aren't responsible for clearing them, but you also can't say that they can't clear them out.
Right.
So if you had an apple tree and the limb was extending over, as long as you could prune that tree without killing the tree, I believe in most instances that's permitted.
Right.
I don't know. I was going to say, this just gave me a thought about you guys are familiar with Monsanto and their what was it, genetically modified.
They're blowing their
it's landed in other people's
yeah.
places, and then they got sued because they're growing like patented seeds or something like that. So that's obviously maybe not just real estate. That's some other like patents.
That's patent. Yeah.
That gets into
that's guerrilla warfare. That's what that is.
I mean, if it's gonna germinate and just fly off and do whatever, like
stop growing my seeds.
I mean, make sure your seeds don't fly away. I mean, I don't know what to tell you. No, it is what it is. But no, that sounds like a lot. Well, let's get into, like in terms of ownership. Obviously, you work with a lot of investors.
Yeah.
Can you talk about like joint tenancy or other rights of tenancy that people should be aware of when they're getting into a partnership, or maybe even buying property with their loved ones or family?
Yeah. So there are specific types of tenancies in Oregon, and I didn't look this up before I came, so forgive me if I misquote. But the most common vesting for people who are married would be tenants by the entirety, which means that it's common property. You own all of it together as communal property. Right.
And if one of you dies, it
automatically vests with the spouse.
Yeah.
The next form would be joint tenancy, which means that you own property in common, but you each retain a separate, we call them bundle of sticks, but your ownership rate is separate from your other, is that right?
Partner? Like
I'm describing tenancy in common.
That's tenancy in common, right?
So
some states call it tenancy by entirety, joint tenancy, I think, right? Or
it's a separate subcategory, but tenancy by the entirety.
Or maybe one's if you're not married or something like that.
A tenancy by the entirety in other places might be called a joint tenancy with right of survivorship.
Yes.
Which allows it's the same. You don't have to be married. Tenancy by the entirety is only for married people.
Right.
In a joint tenancy with right of survivorship, the tenancy remains in place, and then if one partner dies, that ownership right goes to the remaining title holder.
Right. Both own it 100%.
Yes. Tenancy in common is when you have an undivided interest in property, but you hold either a specific percentage or 50-50. And then in that particular context, when one of you passes away, your interest in the property flows through your estate planning or
probate.
Yes. Probate. Right. So just kind of the overall inheritancy laws. So usually in that instance, your interest would either go to your spouse if you're married, or then your children with some statutory defaults. If you have a trust, that means that asset has to be probated and put into your trust. So if you have any type of title property, making sure that ends up in your trust is ideal.
Okay, and talking about obviously death, it's kind of a sore subject, but can you talk about like not having a will and not having an estate and how complicated it can make things? And
not everyone understands probate, like what we mentioned what happens if you die if you own it 100%, but like you said, so Stephen and I, we have a property tenancy in common, right? So if I were to die, I have it set up so it passes on to family. But let's say I didn't have family and I didn't have it set up. What happens then, like with probate situation?
Are you talking about the duplex?
Let's just say that.
That's a little bit different because you don't have a tenancy in common there. You have an interest in an LLC.
Oh, that's true. Yeah, that's true.
So your operating agreement is the operational document, and it talks about how that property is going to be dispersed, which is great. If you own property as tenants in common, our recommendation is that you have a tenancy in common agreement that goes with that. And kind of in the same way that an operating agreement describes what happens to the property, the tenancy in common agreement handles what you want to happen to your residue.
Oh, so like a separate written agreement that's not part of your
right. And
loan and title documents.
Yeah, and that's usually what we recommend whenever you're taking title as tenants in common, but you intend for specific things to happen that aren't in accordance with the statutory defaults. Because for all property in Oregon, if you don't have something in place, there is a default of what happens to it through either the inheritancy laws or through the real property ownership laws that relate to that particular type of ownership. So there are defaults in place, but it does make it complicated because usually if property is held by two individuals and their individual names, you would have a set tenancy in common, but person A passes away and the beneficiaries of person A would have to probate that interest and then determine what happens to it, because there's no written document telling the court what to do. Mm-hmm. So whenever you retain an interest in real property in your individual name, whether you have a trust or estate planning or not, that property is going to have to go through probate because it has to. The court has to provide a judgment that tells the record holder what happens with that title interest, or it ends up as a cloud on title.
Okay.
Yeah. It's complicated.
It is. And for me, as someone who has multiple properties with multiple partners, is there like an overarching will or document that I can get that just, hey, like when I die, this all goes to my wife or sister?
Yeah, if you have a lot of individual properties, our advice, well, I'm not an estate planning attorney, but typically the advice would be to put all of those title interests into your trust, and then your trust can be the kind of overall document that avoids probate and just kind of because you then have a representative that's established who can take those property interests and allocate them the way that you want them to be allocated.
So you're essentially deeding the property to your trust?
Yes. So what you do is you deed your property to the trustee of the trust, and usually that would be a revocable living trust that becomes irrevocable upon death. So once that happens, that interest, it vests in the trustee, and the trustee is able to do both in life and after death whatever you told them to do using your trustee documents. I mean,
and I know you're not an estate planning lawyer, but do you have a general idea what that might cost versus like obviously not doing that and dealing with probate and how long?
I don't know how much probate costs. I know it takes forever.
It's not a cost to you; it's a cost to your heirs.
Yeah. Maybe I don't have to worry about it. No, I was kidding.
And it depends. It really depends on how many assets you have, how many beneficiaries you have. I don't.
Yeah, because usually when you're setting up a trust, you're going to put all your properties in it, and then you're going to also have to go through all your financial accounts and put those in as well, right?
Right.
You're not going to just do it for a few things.
Right, and so when my husband and I set up our trust, we deeded our house into the trust. There are asset classes that are non-probate assets, so they can transfer through
like your IRA or something like that, because you've already set the beneficiary when you set up your IRA.
So sometimes that beneficiary would be your trust, sometimes it might be your children or your partner or whatever. So it depends on how many assets you have, how many heirs you have, kind of. When you have minor children, there's an extra kind of what happens with the kids.
Right. Are you going to give this to them right away? Or are you going to have someone take care of them and be there?
Yeah, and so it just really is so dependent on what you're coming in with. I would say I don't know at all what it costs now. Probably $5,000.
Okay, well, which is better than however long probate takes, right? And then you have to hire a lawyer for probate, probably.
You do. You don't actually. If you have a relatively small asset class, if your estate is below a certain threshold, you can do a small estate affidavit, which is just like listing all of the things. And then that is pretty straightforward. Most people could probably navigate it without too much problem. If you have 12 properties and they're all listed under you individually, and you have interests in an LLC, and then you also have kind of all of these like cars or random stuff on the side, then it gets really complicated, and then it gets expensive and long.
I mean, you nailed everything but the cars. So, I mean, I'm assuming I should probably go get an estate and deal with that stuff, because if I die, man, it's gonna be a mess. You know?
Yeah, but you don't have to deal with it.
Yeah, and I think our estate planning attorneys do always talk about estate planning as being a gift that you give your heirs, because there are directions, there are instructions. Usually someone knows where everything is. And
oh, is it where you sit in the room, where you see all those movies where somebody passes and you sit in the room, it's like, well, you get this.
Yes.
And you get my gold coin collection. You know, like,
I mean, the trust that I review, sometimes they're huge. They're not like a 4-page document.
Like
it's fat.
Yeah.
Hopefully it's not too complicated. But I wanted to take a step back and kind of get your opinion on the whole NAR thing. I mean, I know we discussed it a little bit, but just your opinion. Do you feel like it was just? Do you feel like it helps anybody? Is it beneficial? What are your non-legal just opinions on how it's going to affect the market?
Yeah. I don't know. I've heard a lot of people who talk about this just being an added cost, that buyers are going to end up paying some portion of a commission. I don't know that it really will change much. It seems like a lot of the statutory fix here was just kind of establishing requirements that reflect the norms of kind of the existing structure. I don't think that the commissions have to change. There was nothing in the language suggesting that it needed to. It's just that those agreements have to be disclosed. I don't think that's a bad thing.
I think it's not displaying the commissions on the MLSs. That's a big thing. So a lot of, and yes, we could still have those 5 to 6% commissions on listings.
It's big for you guys,
but
it means nothing to the consumer, right?
Well, it does. It's perception of.
Well, I mean, they don't see it, right?
No. I mean, I'll say CNN did a good job of
lying. I'm saying they don't see that change because it's on the back end.
Because it's on the MLS.
It's
they're
not
not
something
that
they could really see before.
Yeah, but I think that the messaging that's coming out from the media is like, okay, well, now I have to go, pay my agent, and it's the thing is nothing's really changing, because you might not, because if the seller is properly compensating the buyer's agent, then nothing changes. But now you have to have the conversation, hey, you might have to pay me in this case where, this house doesn't have this, or you're going to have to be unrepresented or figure out a different solution.
Yeah, it's more just like clarifying what the actual cost is, right, of buying a home. Yeah,
well, and then there's the whole lending side of like, okay, you can't fund like the buyer's agent commission, et cetera, et cetera. I don't know that part as well.
Well, I mean, you can't just finance random costs into your loan. No,
I mean, why not?
But of course you can. It can still be, just like it has always been, it can still be a closing cost, right? You can still negotiate closing cost, and to me that's gonna, like, if someone is buying something and they can't afford to pay the buyer's agent, what are you gonna do? You raise the sales price, hope that it appraises, and then get the closing cost to pay the agent, right?
Yeah.
Just like if you can't afford closing costs, to me it's the same thing.
Let's just say it's just gonna make, well, it's gonna push a lot of people out, because that's a lot for a lot of agents to kind of keep track of and deal with and negotiate into. So
yeah, you mean you better be able to explain how it works ultimately as an agent, right?
Yeah, and I'm assuming you Margaret, do you think your business might have an uptick once this goes through, and maybe there's more media about like, oh, I'm gonna go do this unrepresented because I don't want to pay those lazy buyer's agents?
I don't know. It'll be interesting to see if that has any impact on the market. I would say that from my perspective, it likely has less of an impact than like Zillow.
Yeah,
right.
It just kind of makes the listings a lot more accessible than they used to be. I'm sure there will be some type of consequence. I do wonder long term, if we're kind of looking towards just a different type of real estate agent or broker in the future, or just kind of a retooling of what the expectation is associated with that particular service. But I don't know that that's a result of this as much as just kind of records and listings being more accessible and more transparent generally.
Yeah,
because it's pretty different in different countries, the way the commission is structured, the way the representation works. So,
do you have any opinions on, if the economists who are talking about this says this may push down home prices? Do you have any thoughts on that at all? If that's going to happen?
I wouldn't hold my breath. I think that if you know that you can market something at a certain price because that's what the market indicators and the comps are reflecting, changing the commission structure isn't going to bring housing prices down when inventory is so low. This isn't going to be what does it.
Yeah, I mean, like I said, my thought is like, how do you think you're automatically going to cut off 2.5% because you're not paying the buyer's agent? That just, like I said, as fiduciary, I can't even use there's a verb for this. As much as we want to be fiduciaries, like if I'm not getting paid at all, like not that I wouldn't show a house to them, but I would explain. But there's a lot of agents who would not.
Yeah.
And that's just.
I do wonder if there will be some different niche of agents that will be charging differently, but I mean, I know that they've already had some of that. Like I saw an agent was doing that in New York a while back, but it's definitely not like a common practice yet by any means to do something, bill hourly or to bill just like a flat fee or something like that. But that who knows? Maybe there will be some change.
I'm sure somebody's going to try it.
And I think it'll show up differently in different markets where there are, like, the Portland market right now is different than the Salem market in really interesting ways. And I think where there are those just kind of market differences, there are opportunities for setting up some type of alternate structure.
Yeah, I mean, it's like Redfin did that, right? They were like, we're going to charge only 1% or whatever. And
yeah, like I call that the spiral to the bottom. There's always going to be, at the on the listing side, like, I'll charge 3% because I'm still getting my 2.5%. Sorry, I'm not putting out that, I think things like that it's just going to keep pushing the price down and making this business a little bit tougher. And, yes, it sucks for a lot of agents, but it's, like I said, it's the one who provide value who can recoup the amount that they're worth. So
totally,
that's the tough part.
I do think it's likely to push out those people who are just like, I'll just be a real estate agent.
Yeah.
It's not easy.
It's my side hustle, right? So speaking of kind of switching gears here, we talked a little bit earlier about like creative financing options. You briefly mentioned seller carries. What are like some of the more interesting strategies that you find your kind of more savvy investors doing in the market today that the general consumer you wouldn't think of, I guess?
So I think probably our investor class that we see in our clients tends to be people who are kind of at the end of their investing career and are getting ready to kind of step back.
Finding ways to unwind their...
Right.
Like they built 20 rentals or whatever and they're like, this is too much. I want to consolidate.
Yeah. So the concerns in that kind of particular setting are a lot different than someone who's at the beginning stage trying to kind of access that wealth. But I think you kind of see the flip side in that transaction on both sides, because the person at the end of their career is trying to kind of minimize income so that they're avoiding paying capital gains on like a significant portion, and they're trying to protract that while still having ideally some type of income from that property for a longer tail. So we see kind of people who are getting out and kind of allowing for more kind of individualized transactions to kind of acquire that wealth building product. I would say for seller carried financing, it hasn't really changed much. It's the same. I think more people are using it just because interest rates are high, and you kind of see that force people into private lending just whenever the market is kind of in this type of scenario.
And when you're working, so like, let's say, you're working with someone that's unwinding, wants to mitigate their capital gains over time, they're seller carrying. What are you seeing as, like, is there like some sort of standard for terms? Or is it, I mean, obviously it's all negotiable, but is there?
Yeah, I mean, for the most part, seller carried financing for both sides is just a math problem. You have to figure out what fits both sides of that transaction.
Yep.
So it usually in that type of instance, we would say, all right, go and talk to your CPA, figure out what what gains you can offset, and give me the formula. And that will kind of impact how much they're willing to take as a down payment, what they're able to take as interest over the long run, and then what they want those payments to look like while the principal is being paid down. Usually in those types of situations, we don't see a ton of people who are taking huge principal payments. It is usually or interest only, because that kind of defeats the purpose. They are trying to kind of match their income over time to minimize those gains. And the CPA is the best person to give them kind of that planning advice. When we're talking about someone who is developing on seller carried financing, it looks different because
that's
usually
interesting to me too.
There is a credit issue or there's a liquidity issue, and so the risks that you're trying to offset there aren't necessarily the seller trying to minimize taking gains. It's we need an alternative lending path that isn't available, and in those situations interest rates are higher, and it kind of depends on what the seller needs to get out of the transaction. It might end up being that down payment is still pretty substantial, and what you would see in more of your typical lending scenario, but it's kind of structured differently. The kind of recapture is different, and some of the rights that they're receiving kind of lines up with the risk allocation associated with that transaction. The other thing that we would see in those types of situations is instead of we don't usually do mortgages, we would do a trust deed and a note. Instead of using a trust deed and a note in a riskier situation, you might have a lender who's selling on a land sale contract, and that just really mitigates their risk long term because they retain the title ownership of the property.
Can you explain a land sale contract,
yes.
please?
So when you're buying a land sale contract, you're buying an equitable interest in the property, which means that you are essentially paying to own, but you don't actually get the transfer of the ownership interest until you've fully paid off the loan. Whereas with a trust deed, you are signing a note, which is secured by a document that acts like a deed to a third party who's the trustee.
That's your typical purchase, right? That's when
right.
you're going and getting a conventional loan, you buy a home, you're on title, but the title is encumbered with a mortgage.
Right.
Whereas this, in your land sale contract, you don't have title until you've paid off the loan.
Right. And so the interesting thing about land sale contracts, in similarly to a trust deed and a note or a mortgage more typically, is the interest of the lender is transferable. It can transfer to anyone at any time. They don't have to give notice to the borrower or...
What does that mean?
It means that, like with a mortgage where the mortgage can be sold from institution to institution, that's the same with a land sale contract.
Oh, they can sell it to somebody. So
they can sell
that's
the
interesting.
Property
and
assign the land sale contract. So what sometimes happens is that has happened. Borrower isn't necessarily aware of it because they're paying into an escrow account. And then you have to figure out how you properly clear title.
All right, because it could be sold and resold. I mean, when they buy it, they still have to agree to the terms of the original land sale.
And they do still have to keep assigning the land sale contract in association.
So whatever legal firm does this original land sale agreement, they'll be notified each time. or someone, where would the record be kept, on title or?
So when we represent buyer, we always recommend that they receive notice every time, just because they might not track it, but at least they have an opportunity to be notified that, whoa, something's changing, and Barbara doesn't own the property anymore. Her son John owns it now, and I need to contact him when I need the deed.
But as a seller, that could be a super valuable asset, actually, right? Because if market rate is 10%, and you have a note that's paying 10%, and then suddenly market rate's at 8 or 7%, you could sell that 10% contract for quite a premium, right? Just like a bond or.
Right, and so it becomes a more transferable asset for the actual title owner of the product, and there is some additional risk for borrower. So it tends to be riskier from the borrower side, but more beneficial from the lender side.
I see that.
And that's kind of that type of instrument, I think we've seen more of and will continue to see more of as rates stay high. And
so do some people use that as a strategy, as like setting up a portfolio intentionally to do that? They're not just like moving out their classes. They're like, I'm going to do this, and I bet this is going to be a land sale contract for me. I never thought about that as a strategy. That makes sense.
Yeah, and I think it makes sense in uncertain markets where you're not exactly sure what you want to do with a particular property. It is an investment property, and you're just like, well, let's see what happens. Okay,
but of course you need to own it free and clear to do that, or not? Or can you pay off the current mortgage and set a new?
It's always best when you own it free and clear, and usually it would be considered a default under most lending instrument, because it would technically be a transfer, but because you retain title, it doesn't look like a transfer.
I see.
So a lot of people will use that as wraparound financing.
Okay, that's basically a wrap. Okay. Interesting.
Yeah. Well, just to kind of wrap things up, if someone was trying to get into your field in real estate law, like, how could they get started?
Well, you gotta go to law school.
I guess that's one step, I guess. Okay, well.
Only 3 of them in Oregon. Only 3 of them in Oregon, right?
Yeah. Well, usually I think there is so much education involved in where our industry is and what our practice looks like. I really always recommend that you try and get some type of job shadowing experience and make sure that you understand what being a lawyer really means, because there are a lot of TV lawyers, and you kind of watch it and you're like, wow, that looks really great.
Yes, out of order.
I just confessed right on the stand. How hard is that? But, there are quite a few costs, and, there's a lot of stress. It's not an easy job. So just making sure that you understand what the costs are, and it's worth it to you to go to law school and kind of go through all of the licensing tests and all of those types of things, I think is step one.
Yeah, is there a way of dipping your toe in the field where it's like, oh, I see what they're doing and I like this, I get energy out of it, maybe it's something I want to do?
Yeah, most firms will have an administrative assistant or a filing clerk or something like that, where you can do you're not doing the actual work, but you're adjacent to it, and you can kind of see what the day-to-day is of that type of work.
Are attorneys in their offices now post-COVID, where you can listen to them talk on the phone and stuff too in an office setting, or does it just depend on the office?
It really depends on the firm. There are a lot of firms, especially Portland firms, who are fully remote now. They've kind of given up their leases. They're not doing the in-person thing anymore.
Because I can see how that would be hard for someone wanting to get in the field. Because same for me, I feel like it's really hard, and probably for you too, for new agents that if you don't have that office setting where people are all around you talking on the phone, giving advice, and you're learning a little satellite type thing.
Yeah, I think Yes, I think it's really difficult to do it without any type of exposure. I think so. Usually, when you become a lawyer, you join a firm as an associate, or you do kind of some other associate type work. And a lot of that working, especially during your first year, is figuring out how you be a lawyer, because law school doesn't really set you up to do that well.
They didn't train you how to get accounts?
No. Turns out. So if you don't have kind of people teaching you how to do that, I think it's really difficult to learn how to do it well. And so our firm's philosophy is that we're better when we're consistently in person. Yeah. And I don't know if that will be, if people will come back to that or not, but it's hard to.
So you guys are in person like 5 days a week or whatever, yeah.
Yeah, and there is definitely more flexibility now, but our firm culture is very much collaborative and like in person. Yeah. In suits. So.
I was gonna say, it's like, is this like Suits? You have a Harvey Specter?
It's not as toxic, but
that's fine. No, I was gonna say, when you said you don't learn everything in law school, you don't learn everything from your real estate license test, and I'm sure he didn't learn everything from his 2 days getting his mortgage license.
Hey, 40 hours. 40 hours.
Yeah, it's it'll be interesting to see if people start wanting to come back more. I think it's lonely.
Would you say, like, in terms of like the different practices of law, that real estate law is riveting? Or
I like it.
And I guess there's probably real estate has so many subfields too, right?
Yeah. I mean,
because you could be in-house with a developer,
sure.
Or you could be, at a firm like yours, or lots of different things, right?
Yeah, and I would say that it really depends on your personality. If you are the type of person who really likes analyzing documents, then real estate law is a great field for you.
I'm just like, that doesn't sound like anybody.
After you said analyzing documents, he's like, oh, no.
But there is also a really relational component to it, because you are working through complex problems and complex situations with people, and so there is a lot of customer service, and I think it is interesting. Like, you are watching people build something from just money. So whether it's buying a house, or buying property and developing it, or buying an investment property, you are part of that process, and you usually are the calmest person in the room. So it's I don't know. It's fun.
Can I ask, has it informed your kind of investment?
Right, yeah. Has it made you more risk averse or less risk averse? I'm curious.
That's an interesting question. I think most attorneys are fairly risk adverse. It's why we're the ones in the back of the room that's like, but what happens if this happens?
Right. But you also get to see so many creative strategies, and actually know what the protections are or not, right?
And I would say when you look at my practice group, we have kind of a spectrum. We have our kind of most established partner, who's been practicing the longest, does have substantial real estate investments, which he has been able to kind of use his know-how to kind of
helps you
move through that space and really make some good decisions for himself and investments that have really panned out. We also have an attorney who is more risk adverse and is like, well, if I'm gonna invest in anything, it's not going to be the real estate market, because my job is already tied to the real estate market. So I need to diversify a little bit. And
that's interesting, because there is that thing where I know plenty of mortgage lenders that don't invest in real estate at all, and I know real estate agents that don't invest in real estate at all, but then I know some
because they can't afford it.
Well, there's that, but then I also know some that's all they invest in, because that's what they know and that's what they have access to. Because you're right. There's both sides. Like you said, you're not diversifying your assets, right? But then there's also the other side of having insider knowledge and.
Yeah, and I think probably the way that showed up most for me is just in my own purchase of houses, I've kind of seen the market shift coming a couple of times, and we've been able to just navigate that better than most. So that's probably, and knowing how to kind of pull equity out and what the options are and what the costs are, that is probably where it shows up the most. But I don't know. I haven't. I do a lot of kind of advising work and pro bono work with nonprofit organizations, and that's enough. Like, this is probably the right move for this organization to grow and kind of develop something that's good socially, that I feel less concern in that space.
Right. That makes sense.
Yeah. I'm not redeveloping a mall or anything. We'll see.
Tough one. Well, if people are looking to like kind of get a hold of you or get in touch or have some questions about real estate, how can they get a hold of you?
Yeah, the best way to get a hold of me would be either through email or we have a contact form on our website. And my email address is just margaret@sglaw.com. So.
Okay. Great.
Well, thank you so much for your time. We really appreciate it, and looking forward to seeing how everything turns out.
Yeah, thanks for having me.
Thanks.